This is Bankruptcy on Tape with Kirkland Breakup Fees. Debtor's motion for entry of an order authorizing and approving certain bid protections for the proposed plan sponsor and granting related relief. The above captioned debtors and debtors in possession state the following in support of this motion. The preliminary statement reads, since the outset of these Chapter 11 cases, the debtors have diligently worked to identify a sale and restructuring transaction that maximizes the value of their liquid and illiquid assets and businesses for the benefit of their account holders. To that end, the debtors, in close consultation with the Official Committee of Unsecured Creditors and its advisors, have pursued a dual-track process of marketing the debtors' retail platform and mining business while simultaneously evaluating a potential standalone reorganization. That months-long marketing process resulted in 6 initial, non-binding bids that the debtors and committee have worked to improve in order to identify the bid that provides the value-maximizing solution for the debtors' liquid and illiquid assets. As disclosed in the debtor's statement with respect to the status of the debtor's Chapter 11 plan process filed under Docket 2066, the debtors and the committee identified NovaWulf Digital Management LP as the potential purchaser and plan sponsor in restructuring transactions that will A, provide for the distribution of a significant majority of the debtor's liquid cryptocurrency to account holders on the effective date of the Chapter 11 plan of reorganization to be proposed by the debtors, and B, create a new entity or entities that will operate and or manage the distribute that value to earn creditors in the form of equity in NewCo, which creditors will receive 100% of the common equity of NewCo. Beyond serving as a vehicle to store and, over time, monetize the debtors' illiquid assets, NewCo will be a public and fully regulatory compliant company that will operate and expand into a variety of cryptocurrency-related businesses, including, among others, staking, mining, lending, and other potential future opportunities for the purpose of delivering value to its creditor shareholders. NewCo will be predicated on transparency, governed by a board of its creditor shareholders, as further detailed in the plan term sheet, as defined herein. The NewCo structure is, and was expressly designed to, deliver value to the debtors' account holders over time as the cryptocurrency market continues to improve. Critically, NovaWulf has developed partnerships with service providers that have the required licenses to operate the segments of NewCo, subject to licensure, and distribute tokenized equity securities under the plan in compliance with all regulatory requirements. NovaWulf does not have, and NewCo will not have, any affiliation to the debtors or their founders, and will be a regulated entity with financial reporting obligations consistent with public company best practices. The plan will also include a 70% recovery for convenience class creditors who hold earned claims below $5,000 and will present settlement options for holders of custody claims and retail loans. The plan will also provide for a litigation trust to pursue claims and causes of action against Alex Mashinsky, Daniel Leon, and certain other insiders, among other claims and causes of action that will be agreed upon by the debtors and the committee. Contemporaneously with the filing of this motion, the debtors, the committee, and NovaWulf entered into a binding plan sponsor agreement attached here to as Exhibit B, which sets forth the terms of the proposed transaction, the commitments and obligations of the parties with respect to the restructuring transactions, and milestones for the disclosure, solicitation, and plan confirmation processes, and the consummation of the restructuring transactions. Attached here too as Exhibit C is a presentation that provides key features of the proposed transaction, the plan sponsor, and NewCo. While the plan sponsor agreement represents a critical step in the debtor's sale process, it is not the final step. As set forth in the Notice of Selection of Stalking Horse Bidder and amended dates and deadlines with respect to bidding procedures for the potential sale of substantially all of the debtor's assets filed under Docket 2150, the debtors have selected NovaWulf as the proposed plan sponsor. Although the debtors and the committee have entered into the plan sponsor agreement and believe that the NovaWulf transaction represents the best option presently available to maximize the value of the debtor's assets, The debtors and the committee will continue to have the ability to engage with other bidders and potential bidders with respect to alternative proposals between now and April 17th of 2023. The plan sponsor agreement includes a broad fiduciary out provision that allows the debtors or the committee, consistent with their fiduciary duties, to terminate the plan sponsor agreement to the extent the debtors and/or the committee identify an alternative proposal that is superior to the proposed NovaWulf transaction. The plan sponsor agreement provides material value to the debtors and their estates by securing a commitment from NovaWulf to serve as plan sponsor for a transaction the debtors and committee believe maximizes the value of the debtors' assets. Pursuant to the proposed sale and restructuring transaction, NovaWulf has committed substantial resources, including the investment of $45 million of cash to implement the restructuring transactions that will facilitate recoveries for the debtors' creditors. And, to the extent the debtors and the committee identify an alternative proposal that is superior to the restructuring transactions between now and April 17th of 2023, the debtors and the committee's capacity to solicit such superior proposal is predicated on the framework provided by the plan sponsor agreement with NovaWulf and the debtors and the committee's capacity to take actions consistent with their respective fiduciary duties under the plan sponsor agreement. In recognition of the framework provided by the NovaWulf transaction, the debtors file this motion to provide bid protections to NovaWulf that are typical for stalking horse bidders in Chapter 11 and that are reasonable and appropriate in light of NovaWulf's efforts prior to the date hereof and commitments to continue such efforts in furtherance of the restructuring transactions. Specifically, the debtors, the committee, NovaWulf, and their respective advisors undertook enormous efforts over the past few months improving upon the proposed transaction, including hard-fought negotiations and substantive analyses of complex legal issues. These efforts culminated in the plan sponsor agreement, which creates the architecture for a complex and structured transaction designed to maximize the value of the debtors' assets for their account holders over time. NovaWulf and its advisors have spent thousands of hours of time and have incurred significant legal fees and other expenses in formulating and negotiating the proposed transaction. And, moving forward, NovaWulf will continue to expand significant efforts and incur substantial costs in negotiating and drafting the definitive documentation with respect to the restructuring transactions. Additionally, NovaWulf is incurring expenses on behalf of NewCo, e.g., expenses incurred establishing payroll and other infrastructure in connection with the formation and organization of NewCo and any of its subsidiaries, filing various corporate documents on behalf of NewCo, transferring assets to NewCo, and addressing regulatory matters that NewCo would bear in any transaction structure. In a uniquely challenging environment for cryptocurrency and cryptocurrency-related businesses, coupled with significant government and regulatory scrutiny and oversight, NovaWulf has agreed not only to invest in NewCo and partner with the debtors to consummate the restructuring transactions, but also to continue to expend significant resources to pursue the restructuring transactions while the debtors and the committee have the ability to exercise their broad fiduciary out under the terms of the plan sponsor agreement to pursue a superior alternative transaction. Therefore, as part of the plan sponsor agreement, and as a condition of NovaWulf's entry into the plan sponsor agreement, the debtors, in a sound exercise of their business judgment, seek to provide NovaWulf with the bid protections, a breakup fee of $5 million, and an expense reimbursement, each as defined herein, of up to a maximum of $15 million to compensate NovaWulf for the substantial time and resources it has spent and will continue to spend in negotiating and consummating the complex and novel restructuring transactions on the terms set forth in the plan sponsor agreement. The bid protections will ensure that NovaWulf is properly incentivized to continue expending considerable resources to develop, document, and ultimately implement the restructuring transactions. To be sure, while the debtors believe the NovaWulf transaction represents the best option presently available to maximizing the value of the debtors' estates, to the extent another bidder proposes a transaction that is superior to the restructuring transactions, the debtors have the flexibility to consider and, if appropriate, act upon that transaction in an exercise of their fiduciary duties. Accordingly, providing the bid protections to the plan sponsor is a sound exercise of the debtor's business judgment and should be approved.